In a significant blow to one of the Biden administration's flagship programs, the U.S. Supreme Court has thrown out the plan to forgive student loans held by 14 million Americans. This decision deals a setback to the White House's $430 billion program, which was considered a crucial strategy to solidify President Biden's support among younger Americans. The case not only has financial implications, but also highlights the diverging views on executive power between the White House and the Supreme Court. President Biden has shown a willingness to take assertive actions in response to economic, immigration, and other crises when faced with a gridlocked Congress. However, the court, now comprising a conservative supermajority with skepticism towards federal regulatory authority, has repeatedly blocked administration initiatives and established new doctrines that restrict agency discretion in unforeseen circumstances not explicitly addressed by existing legislation. During his 2020 presidential campaign, Biden vowed to pursue legislation to cancel $10,000 in student debt per borrower. However, with Congress unable to find consensus on the matter, Biden sought an alternative route. Amid pressure from progressive voices to fulfill his promise, the administration made the decision to forgive certain borrowers student debt during the COVID-19 emergency a permanent measure. Initially uncertain about the administration's authority to take such action through executive action, Biden expressed doubts in a CNN town hall in 2021. Yet, after extensive internal discussions and legal research, the president concluded that emergency powers granted by Congress to the Education Secretary could be interpreted to encompass the permanent forgiveness of student loan debt. The crucial language conferring this authority was found in the HEROES Act, a federal law enacted after the September 11, 2001 terrorist attacks. The HEROES Act was subsequently expanded to ensure that individuals affected by military operations or national emergencies would not suffer undue financial burdens. The COVID-19 pandemic prompted both the Trump and Biden administrations to pause student loan repayments. However, the specific language of the HEROES Act did not explicitly outline whether the relief should be temporary or require full reimbursement by the government. In January 2021, just before leaving office, the top lawyer of the Trump Education Department issued a memo suggesting that while the statute did not explicitly prohibit blanket loan forgiveness, such a prohibition could be inferred from the structure of the legislation. Nevertheless, Biden's Education Secretary, Miguel Cardona, disagreed with this interpretation. In August 2022, Cardona authorized the permanent forgiveness of up to $10,000 for borrowers earning less than $125,000 per year, with an additional $10,000 of relief for those holding Pell Grants, typically awarded to the neediest students. Cardona's directive drew upon the department's prior experience of pausing loan repayments for borrowers affected by natural disasters, such as hurricanes and wildfires. It highlighted that default rates had significantly increased when repayment obligations resumed for borrowers whose bills had been temporarily paused. Assistant Attorney General Christopher Schroeder, who heads the Justice Department's Office of Legal Counsel, provided a legal opinion supporting Cardona's directive. Schroeder argued that the HEROES Act granted the Education Secretary broad discretion to modify or waive student aid programs during emergencies. However, Republican officials from 6 states remained unconvinced and filed lawsuits to block the plan. They contended that it would adversely impact state finances since the discharged debt would not be classified as taxable income. Moreover, they argued that the Education Secretary lacked the authority to eliminate billions of dollars of debt from the Treasury's records. In a ruling that halted the plan's implementation while the litigation proceeded, a federal appeals court in St. Louis sided with the Republican states. Similarly, a federal judge in Fort Worth, Texas, hearing a lawsuit from borrowers who claimed they were unfairly excluded from the maximum relief provided to others with student loans, issued a similar order. The Supreme Court's decision to throw out the Biden administration's student loan forgiveness program not only delivers a blow to the White House's economic agenda, but also sheds light on the ongoing battle over executive power and the limits of agency authority. As the issue of student loan debt and relief continues to be a pressing concern for millions of Americans, the decision raises questions about the path forward and the potential avenues for Congress to address the issue. In the coming months, as a separate pandemic-era pause on student loan repayments is set to end, concerns grow about the financial pressure that the estimated 14 million Americans with student debt will face.